I can now hand over to Toby, who's going to start speaking.
Welcome everyone. Thank you for joining us. I'm Toby, as Joe said, and you have me first of all. I'll be talking about the cheery topics of death and insolvency, and then I'll be handing over to Raj, and Raj will be taking us through insolvent estates and covering insolvent beneficiaries and legatees. Now, we're anticipating that most of you are probably private client solicitors rather than being insolvency practitioners specifically. So I've begun by setting out the sources that you'll need for understanding this sort of stuff. So the primary legislation is the Insolvency Act 1986, supplemented by the Insolvency Rules 1986, and then specific to us, the catchily named Administration of Insolvent Estates of Deceased Persons Order 1986. So through this talk, when I refer to the 1986 order, that's what I'm talking about. Now, the sort of text that you'll all have to hand, Williams, Mortimer and Sunnock's, Lewin, that kind of thing, they have bits in them about insolvency. But if you're going to be getting into a sort of heavyweight example of this kind of thing, then you might want an insolvency specific text. So I put them there. Seeley and Millman is the one I tend to have around, but Muir Hunter and Shaw, Miller and Bailey are also available, depending on whether you've got a sort of Westlaw or a Lexis subscription. Now, insolvency is defined in different ways throughout the 86 Act, depending on whether you're talking about a company or a private individual. But an insolvent estate is where the estate of a deceased person is insolvent if, when realised, it will be insufficient to meet in full all the debts and other liabilities to which it is subject. Now that sounds quite straightforward. The primary difficulty with it is, and it's a difficulty that's sort of almost unique to estates, is that ordinarily when a person dies, you don't know the full extent of their assets and liabilities. You may not know it for 6 months, you may not know it in a complex estate for some 5 years or so. And all along, you may well have before you an insolvent estate. Now, what are the implications of that? Well, if an estate is insolvent, the beneficiaries get nothing. Now, there are ordinarily some people who are expecting to get something, and there are some people that we will have all encountered who have a very distinct and firm sense of entitlement that they should get something. And so those people are going to be fiercely disappointed. Now, you also have creditors who will not be receiving all of their debts. They'll be getting what you'll hear sometimes as pennies in the pound. So you have two groups of people who are very displeased. And that's often quite acrimonious. It can be quite a difficult position for a personal representative to find themselves in. And frequently it results in litigation. Now, the timing of the insolvency is important. If a petition has been presented during the person's lifetime, then it should simply continue as though the person were still alive, unless the court orders otherwise. And you get that from Article 5 of the 1986 order. But what we're concerned with, what the rest of this talk is about, is where no petition has been presented during the person's lifetime. Now, if we start with that sort of period, as there invariably will be, in between the person dying and somebody obtaining a grant in their estate, what you can have is creditors applying for a receivership order, or for the appointment of a receiver, using the power at Section 37 of the Senior Courts Act. And it will be made in circumstances where it appears to the court to be just to do so, which is pretty unhelpfully broad description. It was analysed in the case of Aeroflot against Berezovsky and Glushkov. Now, this case attracted a fair bit of attention. The Russian state airline suing two oligarchs, effectively. And during the course of those proceedings, both of those oligarchs, no doubt entirely unconnected, died. Morgan said this about, well, it was this was an application brought by Aeroflot in relation to the estate of Mr. Glushkov, to have a receiver appointed over the estate. And Ms. Justice Morgan said this in relation to the application. What the court is concerned with on an application of this kind is the question of what is in the best interests of the estate and interested parties in the estate, who include the beneficiaries under the will, but who also include the creditors and possibly potential creditors. The focus should be on the best interests of the estate considered in that way. And he then went on to express a little bit of displeasure at the way that Aeroflot had done it. So the application which was made by Aeroflot was not made from that standpoint. The application which was made by Aeroflot was from the standpoint of a hostile litigant seeking to control the activities of the rival party to the litigation. Now, in the event, Morgan did make the order, and in fact, he appointed the person or the people that Aeroflot had initially been suggesting be appointed. But it's a bit of a stark warning as to the way in which these applications should be presented. Now, we'll come on to how it is that these estates are going to be administered, but if it's going to be by personal representatives out of court, then it's often going to be more suitable for them to apply, or somebody on their behalf to be applying for a grant ad cor. Now, there are three methods of administration. We set them out there. Firstly, by the personal representatives under the direction of the court. That, in my experience, is not ordinarily used. Secondly, out of court by the personal representatives. Now, anecdotally, that is much more common. It doesn't ordinarily, to administer an insolvent estate in relation to a company or an individual who's alive, you must have a licensed insolvency practitioner, and that requirement is at section 2922. But Article 4.3 of the 1986 order disapplies that. So the personal representatives, whether they're lay people or solicitors or whatever, they can administer the estate even though it's insolvent. And the last way is by an insolvent administration order. So either the personal representatives can apply or the creditors can apply. When the order is made, then the estate vests initially in the official receiver, but then a trustee in bankruptcy, who will be an insolvency practitioner, will be appointed, usually by way of creditors' meeting. Now, the 1986 Act sets out the order of priority for creditors, and you'll find that at Schedule 6 of the Act. But that's adjusted by Article 4.2 of the 1986 order, so that the reasonable funeral, testamentary and administrative expenses have priority over preferential debts. So preferential debts are things like tax. But your funeral and administration expenses come out first. And that, of course, can be quite important. Secured creditors will still always take priority. That's 2854. Now, there's an important practical consideration. If you're instructed by a personal representative who is administering an estate and you come to suspect that it's insolvent, then Article 12 of the 1986 order amends Section 284 of the Act. And it means that any disposition that is made after the debtor has died is void unless it is sanctioned by the court in advance or it is ratified afterwards. Now that, presumably you're going to be getting paid for the work that you're doing. And so if you're getting paid as you go along and then an administration order is made later, all of the payments to you are void. That's a bit of a problem. So there are various ways of overcoming it, but you could apply for ratification under Section 284, either when you're applying for the order, or it seems you can apply before, as in if an order has not been made. Secondly, you can apply, you can request an indemnity from the personal representatives. Of course, you have to be quite careful to be advising them about their personal liability there, or you can theoretically have the personal representatives pay you personally, and they then indemnify themselves out of the estate. And the way that that should work is that when somebody claims that a transaction is void, the void transaction is the one by which the personal representative indemnifies themselves, and the payment to you hopefully survives. Now, Voss, Dick and Kendall Freeman is a fairly interesting example of ratification. It was one of the Lloyd's names cases. So what happened was this person died, and soon afterwards there's a cash call from Lloyd's, which would make the estate insolvent. And the personal representatives instruct DJ Freeman, I think they were called, who were the predecessor firm to Kendall Freeman. And what the firm does is act for the personal representatives in fighting the creditors' claim, in fighting the Lloyd's the debt, effectively, to Lloyd's. And so they engage in 9 years of litigation. And as you can imagine, it is quite expensive litigation. A lot of fees are incurred, and ultimately they lose. And then Lloyd's gets an administration order. And so everything that has been paid to DJ Freeman and is now in the hands of Kendall Freeman is void. And they apply for ratification. They were unsuccessful. The other case, and the one that will probably help you to remember this the most, is National Westminster and Lucas. Now that is the Jimmy Savile case. So Jimmy Savile died in 2011, and his estate was valued at about £4.5 million. And NatWest were appointed as his executors. Now, they didn't know at the time that he was what he has since been found to be. So he was a serial child sex offender. But in the course of the administration, claimants began to threaten claims against the estate. And the bank came to suspect that the estate may go on to become insolvent. And so they applied for ratification of expenses already incurred. So by that point, they had incurred £1,047,715 worth of expenses, or made distributions and other costs, including having spent £70,000 on Jimmy Savile's funeral. Now, they were successful in this application. It was explained in the judgment that there were effectively 2 time periods to be considered. One where there is no suspicion as to insolvency, and the other one where suspicion has begun. And so paragraph 12 of the judgment explains that it is the position that a more rigorous standard of behaviour and test for validation of expenditure should be applied in the period after an executor is on notice that the estate with which he is dealing may be insolvent. So really that is why you've got to be alert to all of this stuff, because frequently you just won't have any idea. I've been involved in a case where an apparently very wealthy man, the personal representatives going on for a few years making distributions to things. And then a US bank comes along and identifies that he owes them a debt of some £13 million, rendering the estate hopelessly insolvent. And much litigation follows. But so back to the Jimmy Savile case. So the court identified that these expenses can be ratified on 2 different footings. One is that they are unchallengeable. So in relation to legal fees and things, the sum sought is ratified as is. The other basis is that they are challengeable. So in other words, people can challenge the fees and the bills in the ordinary way. And then there's some general commentary in the judgment as to the way that an executor should behave in relation to these things. So it reads, in light of the claims against the estate and the real risk that it may prove to be insolvent because of them, the bank is obliged to have regard to the interests of the class of claimants against the estate, as well as to the interests of the beneficiaries under the will. The position is in significant respect analogous to that of a company which faces a real risk of being unable to pay its creditors, where the directors are bound to consider the interests of the creditors and not simply those of the shareholders. So this is that difficult time when the estate is potentially insolvent and you don't know. That's when you've got to please all of the people all of the time during that period. Now, the insolvency tool chest. So there are powers available to those in control of an insolvent estate, which are not available to those who are ordinarily administering an estate. And so this is just an opportunity for me to put in a slide about the Takanaka Carpentry Tool Museum, where those are some of the finest woodworking tools to have ever been made. Now, one of them sounds quite familiar to estates practitioners. It's section 421A, and it reverses a decision of the Court of Appeal in 1994 in Re Palmer. In essence, where an insolvency administration order has been made, then the practitioner who is administering the estate, so the trustee in bankruptcy, they can present, up to 5 years after the order, after the application is issued, then they can make this application under 421. Now, they can do it where immediately before the debtor died, they had an interest as a joint tenant. And the order can require the survivor to pay to the trustee in bankruptcy an amount not exceeding the value lost to the estate. Now, that's a bit of a tricky concept sometimes in practice, working out what is the value lost to the estate. Now, the court will have regard to all of the circumstances, so it balances the interests of the survivor, the interests of the creditor, the interests of other interested parties. But unless there are exceptional circumstances, the court must assume that the interests of the creditor outweigh all other considerations. And so it really is quite a powerful tool for setting aside the effect of survivorship there. But the reason why this will ring a bell for most of you is that it's quite similar to Section 9 of the 1975 Act. Similar but not the same, of course. Now, another power in an insolvent estate is to issue a summons to appear. And so this can be in relation to, an application can be made in relation to the debtor's spouse or their former spouse, any person known or believed to have the estate's property in their possession or be indebted to the estate, and any person appearing to the court to be able to give information concerning the bankrupt or the bankrupt's dealings, affairs or property. So it is an extremely wide power. Now, what the court can do, and that's section 366, what the court can do is to compel them to file a witness statement or to produce any document relating to the bankrupt or bankrupt's dealings, affairs or property. So very wide power. Now, it's been explained how it will operate, or how it operates in that case there, Long and Farrer, where essentially it was... the guidance from that case is that it's a lot easier to get an order for somebody to produce documents than it is for them to engage in the potentially onerous ordeal of a private examination. And Long and Farrer also applies an earlier decision called Shearson and Rastogi in 2003, where it said that it is oppressive to require a defendant accused of serious wrongdoing to provide what amounts to a pre-trial disposition and to prove the case against himself on oath. But that oppression may be outweighed by the legitimate requirements of the liquidator. So really it's important to have that bit in mind if you are trying to get somebody to come and give evidence on oath. You need some legitimate reason other than simply you want some sort of pre-trial deposition before you go after them in the main action. Now, these are things that are not overly familiar necessarily to estates practitioners. Transactions and undervalued preferences, and they're in sections 339 to 342 of the 1986 Act. Now, the court may make such order as it thinks fit for restoring the position to what it would have been if it finds that there are transactions in an undervalue or preference within the relevant time periods. So we need to break this down into its constituent elements. A transaction in undervalue is a gift or transaction which provides for the deceased to receive no consideration, or a transaction in consideration of marriage, effectively treating that as being no consideration, or a transaction for consideration of significantly less value than that which the deceased provided. A preference is, of course, different. It's where the deceased put a creditor, surety, or guarantee in a better position in the event of the deceased's bankruptcy than that person would have been in otherwise. And it only applies if the deceased was influenced by the desire to produce that effect, to put the other person in a better position. Now, that desire will be presumed if the preference is made in favour of an associate. And so for that reason, we come on to, well, we'll come on next to look at what an associate is. But just before doing that, I want to mention that these applications in relation to a transaction in undervalue or preference, they are not proprietary claims. They are prospective claims. You get that from the authority of a case called Re Ramatan in the Court of Appeal in 2011. So an associate is a very wide term in this context. So it includes present and former spouses, siblings, uncles, aunts, nephews, nieces, parents, grandparents, children, grandchildren, great-grandchildren. It includes people who are related by half-blood, stepchildren, adopted and illegitimate children. It includes professional partners, the spouses and relatives of partners, employees, employers, and trustees are associated with the beneficiaries of the trust, and with the beneficiaries, relatives, and associates. So it's sort of almost at each stage, it is the category is doubled because it is the associates of all of these people as well. So the deceased is assumed to have been insolvent at the time of the transactional preference, if the transactional preference is in favour of an associate. Now that is why you'll see when we come on to timing that is why whether the person is an associate is so important. Now, Article 23 of the 1986 order modifies these time limits so that they run so that they run backwards from the date of death rather than from the date of the presentation of the petition. Now that's important because, of course, you are significantly extending the time period. Because if you have in mind that you may not be realising that these estates are insolvent for a year or 5 years perhaps, and so the insolvency administration order may not be the application for the insolvency administration order might not be presented for a year or for 2 years or for 5 years, and that significantly increases the scope of these powers. So looking at the timetable, if it's a transaction in undervalue, then it will reach back 5 years, or you can reach back 5 years if the debtor was insolvent at the time when they made it, or if they were made insolvent by the transaction, and 2 years if they weren't. Now, a preference, if it is not also a transaction in undervalue, you can only reach back there if the deceased was insolvent at the time, but it's 2 years if it was to an associate, and it's 6 months to anyone else. Now, those tools that we've just been discussing are only available to trustees in bankruptcy or to creditors. They're not available to personal representatives. So that's a factor in the analysis when you're deciding whether or not the personal representative should be administering these estates out of court. And because we're talking about tools, I've taken the chance to include a photo of some of my favourite cabinet making tools. Now, this is the last bit that we're going to talk about. Time is not relevant if the purpose of the transaction was to put the assets beyond the reach of a creditor or to prejudice their interests. And it's also not then necessary to establish insolvency. Now, that will often, of course, require a bit more investigation, but it's a powerful tool. So the first case that we put there is, I've principally put it there because all of the other cases are far too modern for any talk on a chancery topic. So that was about a baker who decided he was a relatively successful baker of a little baker's shop in Manchester. And he decided that he was going to acquire a nearby grocer's. However, he wasn't a grocer and he apparently didn't know very much about how to run a grocer's shop. And he seems to have appreciated that. And he knew he was embarking on something a bit risky. So he went to a solicitor and he settled all of his assets, or virtually all of his assets, on his wife and children before he took on the grocers. He took on the grocers and it went badly, as it was probably always going to. And the court essentially, he was made bankrupt. I think it was only 3 years later. So actually, by the modern law, you wouldn't have needed to rely on this. But the court set aside that settlement and made the assets available to its creditors. Now, the final case that I'm going to mention is B&IB, an order to set aside disposition under the Insolvency Act 2014. So it's a family case. Now, it's interesting to us estate practitioners because this power is probably also rings a bell with you, because under Section 10 of the 1975 Act, you can, of course, also set aside transactions if they were for the purpose of defeating the 1975 Act claim. So in this case, husband sells a significant business and he transfers approximately £3 million to his son over a few different tranches between 2000 and 2006. In 2009, there's a divorce petition presented by wife, and she relies on the Matrimonial Causes Act trying to set aside those dispositions. She then adds into it Section 423, and then in the course of the proceedings, husband dies, and her advisors decide that they might want to bring an Inheritance Act claim. So they add in Section 10, and it came before Ms. Justice Parker. Now, the proposition from, at this stage, Sun's advisors were that effectively that you couldn't run. Well, lots of attempts to stop anyone interfering with those earlier transactions, unsurprisingly. But one of them was that effectively you couldn't run Section 10 and Section 423 alongside each other. Now, the court said that there are important distinctions between the Insolvency Act 1986 and the Inheritance Act 1975 remedies. Number one, under the 75 Act, the applicant must prove that the disposition was made with the intention of defeating an application for financial provision. Whereas under Section 423, it is necessary to prove that the purpose is to put assets beyond reach or to prejudice interests. It is a much more general purpose. Next, the range of relief is also distinct. So the range of under the 75 Act, the powers are confined to providing for the purpose of making, for the purposes of making of that financial provision, i.e. under the Act, such sums of money or other property as may be specified in the order. And there's a difference between that power and 423, as we can see there. Because the difference is between requiring the disponee to provide a sum of money and on the one hand, and on the other hand, setting aside the transaction. And that will have, in all likelihood, some significant differences in relation to tax. And you can see that in a way because in Section 10, there is provision there in Section 10, 4 and 5 to be making adjustments in relation to tax. Also, Section 10 of the 75 Act requires that the court shall have regard to the circumstances in which any disposition was made and any valuable consideration given therefore, the relationship, if any, of the donee to the deceased, the conduct and financial resources of the donee, and all other circumstances of the case. Whereas Section 423 has nothing like that at all. It's just a general discretion. The court may make the order. So, that's the end of my part. Some bits of this will be familiar to you, but really, I think the takeaways are just keep your eyes out within an estate for there being a risk of insolvency. And if a risk of insolvency materializes, you need to notice it and start acting in relation to it. Because if you don't, there are bad consequences in terms of the fees that you receive and the people that you're representing. And with that, I hand over to Raj. So let me press here.
Thank you very much, Toby. Can you hear me okay?
I can, yeah.
Well, yes, I'm going to speak this afternoon about some very specific issues concerning insolvent trusts, which include trusts on the brink of insolvency, such as this bus has found itself in. Toby's controlling the slides for me. Toby, would you take on to the next one, please? So from the outset, it's important to remember, of course, that the term insolvent trust is a misnomer. A trust doesn't have separate legal personality. Its assets are vested in the trustees, and they're the only persons who are capable of having legal rights and liabilities in relation to the assets which comprise the trust. The phrase insolvent trusts is really a convenient shorthand, and it's one that judges and commentators use. And what we're referring to by that phrase is two situations. The first is where the trustees have incurred liabilities in their capacity as trustees which exceed the value of the trust fund. That's effectively balance sheet insolvency, or they have incurred liabilities which cannot be met as they fall due out of liquid trust assets. So there we're talking about cash flow insolvency. And in practice, trustees should keep both tests in mind. Toby, thank you. The flip side of not having legal personality for the trust is that in general, the trustee is personally liable to meet liabilities they incur in their capacity as trustee. Now, worse still, English law does not distinguish between the trustee's personal and fiduciary capacities, and that's the Investec case from the Privy Council. Now, in the current challenging global and economic climate, this is particularly relevant because the value of underlying trust assets, such as company shares or trust income, such as dividends, is likely to be volatile. Trustees don't want to wake up one morning and find that they can't meet trust liabilities out of the assets anymore. And if the trustee is unable to meet the liabilities he or she has assumed on behalf of the trust, then insolvency proceedings may be taken against the trustee personally, not against the trust. Thank you, Toby. Of course, it's not all doom and gloom for trustees. There are several ways his or her personal liability can be mitigated or addressed. For example, there may be an express limitation of liability in a contract the trustee enters into. In many jurisdictions, unfortunately not in England, there are statutory protections which apply. So for example, in Jersey, the Trust Jersey Law, Article 32, or in Guernsey, Section 42 of the Trust Guernsey Law, they limit a trustee's liability to trust assets where the trustee is transacting with a third party, and the third party is aware the trustee is transacting in that capacity. And I paraphrase there. There's similar legislation in the BVI and the Cayman Islands, and no doubt the availability of that statutory protection is a factor which makes those jurisdictions so attractive for the conduct of trust business. The trustee's right to an indemnity, obviously, is perhaps the most important out of the trust assets for any liability he incurs in discharge of the trusteeship, and on the back of that, the trustee holds a lien or equitable charge over the trust assets for that purpose. It's important also to note that the trustee's right of indemnity out of a trust asset is a form of beneficial interest for the trustee in those assets. And I say a form, in this sense, if the trustee is made bankrupt, that interest forms part of the trustee's bankruptcy or insolvency estate. And trust creditors are then subrogated or can be subrogated to the trustee's right of indemnity, although that right will vest in the trustee in bankruptcy or be enforceable by the corporate trustee's liquidator. Can the next slide, please? So what should a trustee do? If the trustee considers the trust is or is likely to become insolvent within the meaning given before, then the trustee should make an application to court for directions under CPR Part 64. Rule 64.2 provides that it applies to claims for the court to determine any question arising in the execution of a trust. Now, there's a preliminary question, which is who are the proper parties to that application? And this is provided for by Rule 64.4. All trustees must be parties, but also any person with an interest in under the trust who it appears appropriate to make parties having regard to the nature of the order sought. Now, Practice Direction 64B is also instructive. The effect of that is the trustee should exercise judgment as to which beneficiaries or creditors should be a party. And importantly, in the evidence in support of an application under Part 64, the trustees must also set out what level of consultation with the beneficiaries there has been. It's helpful perhaps to compare two cases. There's the NatWest Bank and Lucas case, which Toby mentioned earlier, and the Rawlinson and Hunter case from Guernsey in January 2017. In NatWest and Lucas, prospective creditors of an estate were invited to join a Part 64 application where the claims, if they were successful, would exhaust the estate's assets. Whereas in the Rawlinson and Hunter case, R&H case, creditors of the insolvent trust were held not to be necessary parties in an application for disclosure of trust documents, where the issue was really one between the current and the past trustees only. Next slide, please. So there are several matters which are pressing, which require the court's directions if the trust is insolvent within the meaning given. Now, quite surprisingly, there's very little English authority on these points, and we have to look to, in particular, Guernsey and Jersey for assistance. But some of the crucial areas that need to be decided are these ones. First of all, what is the procedure for determining which third-party liabilities are to be satisfied out of trust funds? The creditor's right to recourse to the trust funds depends upon the trustee's right of indemnity. That may require litigation with the creditor if it's unclear. And so that's something which the court will need to give an indication on or directions on. Secondly, given the trust at this point is evidently insolvent, should the trustee be allowed to pay ordinary administration costs out of the trust fund? That's plainly a pressing matter. Thirdly, should the trustee be allowed remuneration? And if so, at what level? Now, the court's going to be concerned, and we've seen this in cases before, not to allow beneficiaries to be unjustly enriched by effectively receiving trustee services for free. But the court can and has in the past used its inherent jurisdiction to reduce trustee remuneration, where, for example, the trust was in fact insolvent when the trustee was appointed. Next slide, please. Fourthly, a hugely important question in an insolvent trust is what is the order of priority for payment of liabilities if those liabilities are limited to trust assets. That's plainly going to lead to potentially quite a bun fight, as in fact we saw in the Z Trust litigation, where that was a hugely pressing question in Jersey. Fifth, the practical question of how to realise and distribute trust assets and the timing around that, and of course that will take into account the other issues that I mentioned above. And finally, what about the ongoing administration of the trust pending distribution? What steps should the trustees be taking while all of the above are being sorted out? Next slide, please, Toby. So the position in England is one of some uncertainty. There is no established procedure in England as to how a court will determine issues which arise when administering a trust in an insolvency situation like this. Now, it's helpful to compare this to Insol International's standard directions for an insolvent trust, which was prepared in October 2017, and that's available online. That provides a comprehensive and helpful codification of good practice. Now, that could be, it seems to me, easily adopted by the courts, and it'll be interesting to see if the courts do that or take the opportunity to do that if it's presented to them at some point. But the absence of definitive practice means instead that flexibility is the guiding principle in England, and often the courts adapt personal or corporate insolvency procedures into the trust context. As I mentioned, surprisingly, there isn't one reported case in England on administering an insolvent family trust. However, there are reported cases dealing with statutory trusts in the commercial context. The two cases given there, MF Global UK and Pritchard Stockbrokers, both concern investment banks, where it was apparent there was a substantial deficit in the client money, which ought to have been available. Special administrators were appointed under 2011 regulations. In both cases, the court gave directions under its inherent jurisdiction over trusts and put in place a bespoke procedure which was similar to that under the Insolvency Act 86 and the rules, Insolvency Rules 2016 as they now are, for proving and adjudicating on claims against trust assets. So the courts have, in that context, been creative. Next slide, please. Thankfully, however, we do have help from the Jersey and Guernsey courts in the representation of Rawlinson and Hunter Ray Z trusts. This is one of the 2019 decisions and the decision of the Jersey Court of Appeal. Two key questions which were decided was whether the trustee's right of lien takes priority over claims of creditors, and also whether the former trustee's right of lien takes priority over that of a successor trustee. Now, in that case, which will be familiar to some of you, or many of you, and in fact some of you may have even been involved in it, in that case, the former trustee of the Z trusts was drawn into litigation with the liquidators of a company that was within the trust structure. Now, the former trustee settled those proceedings by paying £16.5 million to the liquidators and accepting liability for its own costs in the sum of around £2 million. The former trustee sought to rely on its indemnity from the company and its equitable lien, but by that stage, the Z2 Trust's assets were just £6 million as against total liabilities of £211 million. So the former trustee's recovery, if there was a pari passu distribution, would have been about £300,000 against the £18.5 million personal liability. So the former trustee would have been out of pocket by some considerable way. Now, in that case, the Jersey Court of Appeal, disagreeing with the Royal Court, held, first of all, that the former trustee's right of indemnity takes priority over the successor trustee's right of indemnity. And that's because the former trustee's right of indemnity was a subsisting equitable interest, and therefore the successor trustee took subject to it. That seems quite sensible as a matter of principle. And then secondly, the Court of Appeal said that held that the former trustee's right of lien took priority over creditors who claimed trust assets through the successor trustee's right of lien. So that was, again, on the basis that the various creditors were claiming through, as it were, the doorway of the trustee's right of lien through that equitable right. And that's how different creditors would potentially have priority over other creditors. Can you move forward 2 slides, please? Thank you. So an important question is what are the duties of trustees upon the onset of insolvency? Well, ordinarily, of course, the duty of trustees is towards the beneficiaries, but it's well established in a company law context that as a company approaches insolvency, directors' duties shift to creditors of the company. That is enshrined is perhaps not the word, but reflected in section 172(3) of the Companies Act 2006, which really just incorporates existing case law. Section 172 imposes the duty on directors to promote the success of a company or its members in some cases, but 172(3) provides the duty imposed by the section has effect subject to any enactment or rule of law requiring directors in certain circumstances to consider or act in the interests of creditors of the company. So the question is, what is the balance to be struck? Next slide, please. Now, in the Jersey case in the representation of Z Trust 2015, the Royal Court of Jersey took the view that in insolvency, the trustees' duties shifted to creditors in the same way as occurs in company law. So the trustees, upon insolvency, should treat the creditors as having an economic interest in the trust effectively ahead of the beneficiaries. Now, conceptually, that is somewhat problematic, it seems. And interestingly, the Guernsey Court of Appeal took a different view, or perhaps a more balanced view, in the case of Ure F. In that case, they took the view that in an insolvency situation, the court has jurisdiction to bless an application of trust property that is not of benefit to creditors. But that doesn't mean the court would ride roughshod over the interests of creditors in every case. It was for the court to consider the matter with regard to all those interested in the trust property, including beneficiaries. It seems, of course, that our REF takes a more balanced view, but ultimately, perhaps, what happens is perhaps very fact specific. Next slide, please. Now, finally, I just wanted to mention very briefly the different situation of a trustee being insolvent, not where the trust itself isn't unable to pay its debts in the way described. If the trustee is insolvent, then it brings into play different issues which may or may not overlap with the question of the trust's solvency. Amongst those are the question of remaining in office. Now, the bankruptcy of an individual trustee or the liquidation of a corporate trustee does not automatically remove a trustee from office unless the trust instrument provides for that. If the trust instrument does provide for automatic removal of a trustee upon insolvency, then that trustee becomes a bare trustee, but retains the right of indemnity and lien. Now, At that stage, either a replacement trustee will need to be appointed under the trust instrument, or an application will need to be made to court to appoint a new trustee under, for example, Section 41 of the Trustee Act, 1925. And secondly, there's the question of, well, if the trustee is bankrupt or insolvent, who exercises the functions of trusteeship? Well, again, in the case of the bankruptcy of an individual trustee, the trustee remains in place with full power unless removed or replaced, subject to the terms of the trust. The trustee in bankruptcy does not take on any responsibilities as trustee of the trust. In the case of a liquidation of a corporate trustee, the liquidator has power to conduct the trusteeship where the trustee is not otherwise being removed. And that's a slightly odd situation because the liquidator's job is to administer the company's assets, and of course trust assets are not beneficially owned by the company, but it is a practical and convenient approach. And then a trustee in administration, well, again, the company still acts as trustee, but the acts are now performed by the administrator, or the trusteeship is performed by the administrator and not by the directors of the company that's a trust. And the reason for that is because the Insolvency Act 1986 and Schedule B1 to that make clear that directors remain in office but only have such powers in relation to the company as either the Act permits, which is very limited, or as the administrator permits. The final point to mention, leaving aside trust property, which doesn't fall within a bankruptcy estate or a liquidation, a company's assets in liquidation, is the question of the right of indemnity. As mentioned above, the right of indemnity of a trustee is a form of beneficial interest for the trustee and the trust assets. If the trustee is made bankrupt or wound up, that right of indemnity becomes an asset of the bankruptcy or the winding up, and it's available to the trustee's creditors. But the insolvent trustee's creditors obviously cannot grab trust assets directly. They have indirect recourse to trust assets by an application for subrogation to the trustee's right of indemnity. An important point which then comes up is to identify which of the trustee's creditors can rely upon the interest represented by the trustee's right of indemnity, and which of the trustee's creditors must rely on the trustee's own assets. So those are separate issues which arise and indeed may overlap when you have an insolvent trustee, as opposed to a situation where you have a trust that's unable to pay its debts, or the trust itself is insolvent. Toby, thanks.
So that's all really. I'd like to thank you all for joining us. I don't know quite how the questions bit works on this, so I can't see any questions at the moment. So if any of you do want to either phone us up and disagree with what we've just said, or just have any questions for us about any of this, then we've got on this final slide both of our email addresses, and that's the phone number for the clerks. So that's probably the best one in these slightly strange times. You just phone that and ask for one of us and you'll be put through. But yes, thank you for joining us. I hope you all have lovely weekends and see you again at the next one of these.
Thank you very much.